Hello, my name is Hannah Weiser, and this is Accountants Liability and Securities Law. Today we'll talk about the Sarbanes-Oxley Act of 2002 and its role in accountants' liability and securities law. We'll also identify various securities laws that exist today. We'll define accountants' liability to clients and third parties, the requirements for accountants under the Securities Acts of 1933 and 34. We'll understand accountants' criminal liability and other accountant-client issues, and understand the law and consequences of insider trading. So why does this matter? Well, they have a big impact on business. Accountants manage the financial side of a business. As a result, there's a lot of liability you should be familiar with, either as a future accountant if you plan to be, or just if you're working in a business setting, to make sure you limit your liability. Securities also require companies to follow certain federal and state legislation that you want to be familiar with in an organization. By requiring companies to produce reliable information, private investors and large institutional investors are able to use management-generated information to make informed decisions about what companies to invest in, what companies to avoid, and how long to keep securities before selling them and purchasing new ones. So if you're interested in buying or selling stock, this is helpful information for you. So let's talk first about securities law. Companies have to comply with both federal and state securities law. In addition to federal laws, state laws also regulate these securities transactions. So you might see that you're not required as an organization to report certain financial information at a federal level, but the state you operate in may require it. These state-based security laws are known as blue sky laws. Because federal and state laws can differ, management has to ensure that a company is in compliance with each set of these relevant laws, both at a federal and state level. There are major federal securities acts you should be familiar with. These include the Securities Acts of 1933 and 34, which we'll discuss today, the Trust Indenture Act of 1939, the Investment Company Act of 1940, Investment Advisors Act of 1940, the Sarbanes-Oxley Act of 2002, which we'll get into shortly, the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010, and finally the Jumpstart Our Business Startups Act of 2012. Let's start with the Dodd-Frank Act. The Dodd-Frank Wall Street Reform and Consumer Protection Act, which is located here, helped Congress in terms of enacting this law back in 2010. The legislation focuses on consumer protection, trading restrictions, credit ratings, regulation of financial products, corporate governance, disclosure, and transparency. The Sarbanes-Oxley Act of 2002 has a big role in terms of both securities law and an accountant's liability and can be accessed here at soxlaw.com and is sometimes referred to as the SOX Act. This act was the response to a number of major corporate and accounting scandals, including those affecting Enron, Tyco International, Adelphia, Peregrine Systems, and WorldCom, which you may have heard of. This applies to all companies that are based in the United States, which are required to file annual accounts with the Securities and Exchange Commission. Public companies that are bought and sold on an exchange, for example, the New York Stock Exchange, must comply with this law. So let's talk about some of the major requirements you should be familiar with. First of all, this act created the Public Company Accounting Oversight Board, which ensures investors receive accurate and complete financial information by overseeing this law. It also requires that you report to an audit committee. Auditors must communicate regularly with audit committees of its clients. By having this more regular communication channel, it helps to prevent some of the issues they saw with the companies that resulted in this law. It also prohibits accounting firms that audit public companies from also providing consulting services to their audit clients on topics such as bookkeeping, financial information systems, human resources, and legal issues that are unrelated to the audit. So it's important to understand that in a consulting environment, you might be giving advice and guidance that you don't want to create this inherent conflict with someone who's doing the auditing on the audit side. That you have this overlap and you want to make sure to keep those separate, which is what this law helps to do, so that overlap does not exist. A good example of that, when I worked with Deloitte Consulting, we helped to prepare an agency financial report, which is like an annual report for federal government agencies. This is something they must post annually. Now, our company, Deloitte, was not responsible for creating the financial statements. However, we did need to help in the visual representation of those and making them look good in that report. And so we weren't responsible for preparing the numbers. That was a separate firm, where Deloitte was then responsible for handling the consulting side of that overall project, creating the document and sharing it properly. Now, the next piece of the act you want to be familiar with are conflicts of interest. Accounting firms cannot audit a company whose officer has worked for the firm in the past year. Again, we want to avoid any sorts of conflicts of interest that might exist. A conflict of interest is, when you have someone who could present some sort of bias. Like, if you had some stake in a company and you were trying to get your friend, to make a purchase agreement with them or partner with them because it ultimately will benefit you. So in the same way, accounting firms cannot audit a company whose officers worked for the firm in the past year, because they might have connections still to that firm or sort of extra, information that makes the audit maybe more biased. The next requirement you should be familiar with is that there are criminal sanctions. There are fines and even prison sentences up to 10 years to act as a strong deterrent to corporate malpractice for people who do violate this law and others. So you want to be careful that you don't fall into that category. There also are term limits on audit partners. So with a firm, give me 1 second here. A lead audit partner cannot work for a client for more than 5 years. Okay, that exists because you sometimes develop a relationship when you've been working with someone for 5 years, as some of you might have already. And when you have these sort of long-term relationships where you work in a job and you're there 40, maybe more hours a week, you get to know each other really well. And a lead audit partner could then create that same sort of conflict of interest we saw earlier if they work for that client for more than 5 years. And let's say they need to report something on a financial statement that could hurt the company. The client and the relationship might be so close that they feel that they need to help them in some way and fudge some of those numbers to help do that. So it's really important to try to have these term limits so that you don't have these opportunities to create misinformation. Executive accountability is something I really like to push with students because I really think, as a business student especially, something to think about is how you might become an executive one day and be in this leadership position, and you can't just say, oh, I wasn't aware of these financial issues. As a chief executive officer, a chief financial officer, you have to be accountable for those financial statements. You have a fiduciary responsibility to understand them and to make sure that they're accurate as much as you do your due diligence, that you've really checked. So for example, a good example I like to share with students is that if there's a red flag, you want to prepare for that. If you see on your statement that you're showing great income, but you as a business owner, as the CEO of a business, are going, wait a second, we lost a bunch of major clients this year. We've had huge expenses. We don't have, high income. You should know that that's a red flag and know to maybe ask the accountants to look into it further and dive deeper. So it's your responsibility to, not just go, oh, I didn't know there were financial issues. You need to be aware where there could be issues present when you're looking at these statements and know what to look for. Again, if you see something that doesn't really line up with what you know about your business operations. So let's talk now about an accountant's liability to clients and third parties. You do have some contract liability. So there's a written contract that's usually called an engagement letter. The accountant expresses promises to complete a particular project by a given date. So for example, in that Deloitte example I gave you earlier, we had a responsibility as consultants to have that report available by the time the federal government had to have those reports available because they were required to get it in by that date. So you generally have an important date that you need to follow. It's not just when you procrastinate and miss an assignment for class. That date's very important. And there's 2 requirements then, 2 promises that you'll see in that contract, which are timely completion by that date and also accuracy, doing their due diligence. Negligence, which you'll learn about when we talk more about torts or wrongs, but negligence in terms of an accountant is you can be liable for negligent to a client if you can prove both of the following elements. So first, that the accountant breached their duty. So they broke their obligation to the client by failing to exercise the degree of skill and competence that an ordinarily prudent accountant would under the same circumstances. So what that means in plain English is if you were in the same sort of situation, you should exercise a certain level of due diligence. You should be careful, and have a certain level of practice that you're responsible for, not just as an average person, but as an accountant. And so that's something to be really mindful of when you're doing your work, that you're following the general practices and meeting the requirements. And either if you are an accountant or if you have one working for you, that they're meeting their obligations as well. And an accountant's violation of this duty, if it causes harm to a client, could result in negligence. So again, they have an obligation as an accountant. They break that obligation by not being careful the way another accountant would under a similar circumstance, practicing due diligence, being careful, and acting in good faith. And then that violation of the duty resulted in some sort of harm. If no harm exists, no problem. But if there's a financial loss or other harm to the company as a result, you could be liable. Now, accountant also can be liable for fraud if she makes a false statement of fact, if you lie, or if you know it's not true, or recklessly disregard the truth. So we know when we lie that it's not true, but what they mean by reckless disregard is that you really could have found out the true information if you just did a little bit of digging. So, that means you really need to pay attention, again, follow your due diligence. And if the client justifiably relies on that statement, you made the statement, they're going, yeah, that makes sense. If you make some kind of ridiculous statement that they shouldn't have believed and they chose to believe it, it wouldn't fall in that category. But here the client really, was reasonable in relying on the statement that was made. That could be fraud. Now, there's also breach of trust. Accountants have a legal obligation to keep client information confidential and to use that information only for the benefit of the client. So they have to be careful about how they're sharing information. There are also some obligations to third parties. So beyond just that client, an accountant who commits fraud is liable to any foreseeable user of the work product, the stuff that they make, who justifiably relies on it. And whether or not it's justified that they rely on it really is determined by state law. So under the ultramarines doctrine, accountants who fail to exercise due care are liable only if they know that the third party will see their work product and will rely on that work product for a particular known purpose. This is very restrictive. It gets a little looser in other states. For example, with the foreseeable doctrine, the court held that an accountant who fails to exercise due care is liable to a third party if it was foreseeable they'd received that information, those financial statements, and that the third party relied on those financial statements. And finally, the loosest one is with the restatement doctrine that some states have adopted, where accountants who fail to exercise due care are liable to anyone they knew would rely on the information and anyone else in that same class. So if you knew a certain bank, like Bank of America, would rely on the information, any banks could then be responsible too. So that one's a little broader. Now we're going to take a closer look at two particular securities laws that are very important beyond the Sarbanes-Oxley Act, which are the Acts of 1933 and 34. With the Act of 1933, under Section 11, auditors are liable for any material misstatement or omission in a financial statement that they prepare for a registration statement. To prevail, the plaintiff must prove only that the registration statement contained a material misstatement or omission and that they lost money, there was harm. Auditors can avoid liability if they show that they made some sort of reasonable investigation, due diligence. We'll take a look deeper at this in a moment when we look at a case. This law covers the purchase and sale of securities in the United States as well. So unless falling under one of the statutory exemptions, the 1933 Act requires companies selling their securities to register them with the Securities and Exchange Commission. The objective of this registration is to help ensure that private and institutional investors receive accurate, complete, valid information about publicly held companies, and to minimize the likelihood of a company engaging in fraud or deceit when offering securities for sale to the public. Now, in the Securities Exchange Act of 1934, there's liability for inaccurate disclosure and required filing. So under Section 18, an auditor who makes a false or misleading statement in a required filing is liable to any buyer or seller of the stock who's acted in reliance on that statement. And especially under fraud, under Section 10b, an auditor is liable for making a misstatement or omission of a material fact, knowing or recklessly that the plaintiff relies on it in purchasing or selling a security could result in fraud, as we mentioned earlier. Now, under this law, it requires registered companies to report information regularly to the Securities and Exchange Commission about their business operations, financial condition, and management practices. The information included in the reports is public and is meant to provide investors with as much relevant information as possible about a registered company. Investors then use this information to assist them in making decisions about whether to invest in a company, buy additional securities, or sell existing securities. So for example, if you like to invest and you like buying and selling stock, this information is helpful for you in making the decisions about which you might buy and which you might sell and when. So here's a case to help illustrate some of these concepts for you. Here we have for 19 years, the company Ernst & Ernst, which is auditing a small brokerage firm called First Securities Company of Chicago. We'll call them First Securities here. Leston B. Ney was the president of the firm, so he owned about 92% of its stock. He convinced some customers to invest funds in escrow accounts that would yield a very high rate of return. And indeed, from 1942 through 1966, they actually did. The investments were unusual in that the customers wrote their checks to Ney personally, not to the company First Securities. And none of these escrow accounts actually appeared in First Securities records. So as you might have guessed, there weren't actually any escrow accounts. Ney was spending the customers' money on himself. The fraud came to light when Ney killed himself, leaving a note that described First Securities as bankrupt and these accounts as spurious. And in investigating the fraud, customers actually discovered that Ney had this really rigid rule which prohibited anyone from ever opening mail that was addressed to him, even if it arrived in his absence at the company. So this was sort of strange because there's some information we'll learn later in the course that you really need to be mindful of if you own a business or you work in a business or have a majority holding like he does. Here he's the president of the firm. If he's absent for a number of days and something important comes in that impacts the organization, you generally would have someone like a secretary who's monitoring for these sort of things and bringing them to the attention of other leadership should an issue arise. So it was a weird rule to have them addressed to him and not let people open it. The customers in this case alleged that if Ernst had done a proper audit, they would have found out about this mail rule, which would have led to an investigation of Ney, and they would have discovered the fraud. And so the history of this, the customers file a suit against Ernst. They used Securities Exchange Act, 1934, Section 10B. The accounting firm files this motion for summary of judgment alleging that liability under this law requires scienter, that is, an intent to deceive, manipulate, or defraud. So Ernst & Ernst is saying, yeah, we missed this. We missed the mail rule, this rigid mail rule that Ney had, but it wasn't that we were intending to be deceptive. We weren't intending fraud. We just didn't do a good job. So Ernst admitted it had been negligent, but denied any intentional wrongdoing, and the trial court granted this motion. They said, yeah, you're right, the lawsuit's dismissed. But the Court of Appeals reversed it and said, no, we need to have a trial, and the Supreme Court is now hearing the case, which is what we're looking at today. So the issue here that the Supreme Court took up is, was Ernst liable under Section 10B of the Securities and Exchange Act of 1934 when it acted negligently, so it didn't do a good job, but not intentionally. It wasn't intentional, it wasn't trying to deceive. And so here, the judgment of the Court of Appeals was actually reversed. The Supreme Court said that Section 10B does prohibit knowing or intentional misconduct. So Ernst did not act intentionally negligent. So nevertheless, they looked to the legislative history of the law, and the most relevant exposition of the provision that was to become Section 10B was Thomas Corcoran, a spokesman for the drafters, who indicated in Section 10B, "Thou shalt not devise any other cunning devices. The commission should have the authority to deal with new manipulative devices." So it's difficult to believe that any lawyer, legislative draftsman, or legislator would use these words if the intent was to create liability for just merely negligent acts or omissions. So they're saying here, yes, it's okay, you need to do your due diligence, don't act negligently, but for it to be fraud, there needs to be more of an intent to fraud or reckless disregard. So now let's look at understanding accountants' criminal liability then and other accounting client issues. First of all, there's aiding and abetting. So the Securities and Exchange Commission can prosecute those who aid and abet others in making untrue statements or in connection with the purchase of a sale of a security. So don't help your friends do something bad either. You shouldn't act badly, as we've discussed, and don't be a part of it if somebody else is. You'll also see a lot of legislation around whistleblowing. So under Section 10A of the Securities and Exchange Act of 1934, auditors who suspect that a client has committed an illegal act must ensure that the client's board of directors gets notified. And if the board then doesn't take appropriate action, the auditors must notify the Securities and Exchange Commission themselves. So they have an office there of the whistleblower, which was established in 2011 as authorized in the Dodd-Frank Act we discussed earlier. The whistleblower program rewards high quality original information that results in the SEC in being able to enforce sanctions or penalties against companies exceeding $1 million. And awards can range from 10% to 30% of the money collected in a case. So what that means is that if you help the SEC to take down a wrongdoer, and it results in a penalty exceeding $1 million, you could get a chunk of that, 10 to 30%, anonymously for helping them, for blowing the whistle and reporting that bad conduct. In that way, they help encourage the people who really know what's going on the inside to share. Otherwise, it's really hard to get wind of this wrongdoing and evidence of it. Now, we've talked a bit about criminal liability. These are offenses which may be criminal offenses, including willful violations. So that intentional violation of the 1933 or 34 acts, any wrongdoing in the preparation of income tax returns, and also violations of state securities statutes can result in criminal liability. In terms of the accountant-client relationship, an accountant's relationship with his client may create difficult situations. I sort of alluded to that earlier, and I'll expand here. As the accountant would lose a client if the business failed. So if I have this client as an accountant and I'm preparing financial statements for them, I want them to look like they're doing well. If these statements all represent that they're losing money and they're about to go bankrupt, they fail, I lose my big client. So an accountant who practices any sort of unethical or improper conduct, like not reporting these sort of problems, can be banned from practicing accounting altogether. So the Securities and Exchange Commission rules prohibit accountants from owning stock in a company that their firm audits. This rule is widely broken, but they're not supposed to. And it means that in some cases, information shared between an accountant and client may be protected from disclosure. Something else to be familiar with working papers, accountants own the draft materials they're preparing for a client, but the client gets to control who sees them. And under the Sarbanes-Oxley Act, accountants for public companies must keep these audit work papers for 7 years. There's a lot to be mindful of when you think about the relationship between the accountant and the client, whether you end up being the accountant or if you're on the client side. The last piece we're going to talk about today is just a basic understanding of the law and consequences of what's known as insider trading. You might already be familiar with this, but if you're not, illegal insider trading refers generally to buying or selling a security in breach of a fiduciary duty or other relationship of trust and confidence, while in possession of material, non-public information about the security. So what that means is if you might go about buying or selling stock, you have special information like a vaccine's about to be approved by the Federal Drug Administration, or something that you know as a part of a company that the general public does not. We're about to sell off a piece of the company or about to have a big merger with another company that could help or hurt the stock, and you make a decision to buy or sell based on that. That's called insider trading. So you have material, which means important, valuable, could impact the stock information. And again, the fact that it's non-public, so you have special access or a friend has special access, but nobody else has that access. That's considered insider trading. And the goal of a lot of what we've been talking about today is to help have more disclosure, more accuracy, so that we have more fairness in terms of buying and selling on the New York Stock Exchange or another exchange of the like, some type of public stock exchange. So insider trading violations, are not just someone in a company who has special information and uses it, and buys and sells stock, and it's not information the general public has yet. It can also include tipping such information. So sharing, giving little tips to friends or getting tips from, other people who work at various businesses. So sharing any information that's not public, that someone has private access to, can result in what we know as insider trading. So a good example of this, I'm going to show you on the screen. Here you have a government employee, especially, you know, in the Maryland, DC, Virginia area. You have a lot of government agencies at a federal level. It could be at a state level as well. You have a government employee who tips non-public information used to make profitable trades. So they share information that they know, you know, as a result of their job, but the general public does not. So we have Christopher Worrell, a federal employee at the Centers for Medicare and Medicaid Services, who tells some information to David, a political intelligence consultant, who then shares that information with hedge fund analysts and profits from it. There's $3.9 million in profits from it. Now, that would be an example of insider trading and what that can look like. Another famous example of that you might be interested in looking up, Martha Stewart is a famous celebrity who ran into some trouble with this, and so she's a good example that we've shared over the years, as some students are familiar with her. She ended up resulting in some, you know, fines as well as criminal jail time for her involvement in some insider trading as well. So that was a lot of information in terms of possible liability as an accountant, possible liability if you hire an accountant, they're your client, if you are in a leadership position in a firm, you know, what that can look like, and also securities laws in terms of your firm's stock, you know, especially if it's on a public exchange that you're buying and selling, or if you're just a private investor, you know, buying and selling stock, and some of the requirements and liabilities that you should be familiar with as a part of our class. Thank you for listening.